This is an important case of abuse of the IRS to attack a Tea Party candidate for Congress in October 2010, in the middle of the election in which Obama admitted he got a shellacking. On October 19, 2010, about the same day this was carried out by the IRS, Lois Lerner said this at Duke University in a video. So everybody is screaming at us right now, fix it now before the election. Fix the election. Can't you see how much these people are spending? And she goes on, everyone is up in arms because they don't like it, she said. And she added, the Federal Elections Commission can't do anything about it. They want the IRS to fix the problem. Thank you to Sarah Palin's organization and Rand Paul's organization for making me aware of this. So the IRS hit me during the election, cutting my weekly income to $35 for my wife and I, and threatening to destroy us completely because of one simple thing. I ran for federal office, the U.S. House of Representatives, against safe seat DFLer Betty McCollum as a Tea Party candidate. This case is brought in bankruptcy caused by the governments of Minnesota and the United States as a result of this retaliation. Now the IRS has filed an appellate brief closely related to this case, claiming there is no constitutional right to run for federal office, and so they will not reveal to the court why they undertook this bizarre and completely illegal election activity, and which is described in this case, which retaliated against me severely for seeking federal office. Here are some of the legalities. The case number is 131114, U.S. Court of Appeals for the 8th Circuit. In accordance with federal and local rules 35 and 40, appellant petitions this court for a rehearing en banc. Included in this petition are the statements and arguments of questions that are of exceptional importance, and that en banc consideration is necessary to secure or maintain uniformity of the court's decisions, including conflicts of the panel's disposition of this case with the cases of the 8th Circuit and of the U.S. Supreme Court. In addition, this case is a companion case to 13-1790, Carlson versus IRS et al., which also involved the state of Minnesota as appellee, and involving the state's unitary creditor, Minnesota Department of Revenue, as a party. Both claims raised in 131114, the turnover of emergency unemployment compensation funds and accounting for the deprivation, as well as the claims for damages of constitutional rights for violation of the First Amendment, the right to run for federal office without interference and retaliation from the state of Minnesota, and 14th Amendment due process, are sufficiently intertwined with claims raised against Minnesota there. Determination of tax liability, including EUC benefits owed and IRS taxes collected through Minnesota Department of Employment and Economic Development for the Department of Revenue, the state's unitary creditor, and damages for retaliation against and deterrence of the First Amendment right to run for federal office. That the basis of all claims, that is EUC benefits deprived without due process, violation of the First Amendment right to run for office, and abuse of taxation to collect taxes through min-deed, leading to hardship violation of reducing total income of appellant to $35 weekly from November 2010 to February 2011, revolve around the same aggregate core of facts: the unlawful and damaging deprivation of emergency unemployment entitlements, violating the First Amendment, and unlawfully modifying the determination of both state and federal tax. The bankruptcy court's claim, adjudication, and discharge processes were both related to the scope and statuses of Minnesota's claim against the Carlson's bankruptcy estate, and this is adopted from an 8th Circuit case by analogy. Necessity to secure and maintain uniformity of the court's decisions. The panel conflicts with the following cases. Also, the court must resolve this case uniformly with 13-1790, the IRS case, with which it is sufficiently intertwined that a waiver by the state in one aspect, taxation of EUC benefits for 2010, and unitary creditor status applies to the others as well. As regarding waiver of sovereign immunity asserted under 11th Amendment, Rose versus U.S. Department of Education, 8th Circuit, 1999. What Judge Murphy wrote in Rose needs to be harmonized with the panel's judgment. The case before this court does not present a general question of 11th Amendment immunity, for waiver has long been a factor in bankruptcy proceedings. There is a well-established common law rule that submission of a proof of claim by a state is sufficient to waive any immunity which it otherwise might have had respecting the adjudication of the claim. That's from United States Supreme Court, Gardner versus New Jersey from 1946. That bankruptcy court could entertain a trustee's objections to a claim filed by the state despite its assertion of sovereign immunity. And there's other cases listed here, Burke versus Georgia, which applied Gardner to hold that the state's filing of proofs of claim rendered it subject to liability for violation of automatic stay and enforcement of discharge injunction. And it is stated, Gardner stands for the unremarkable proposition that a state waives its sovereign immunity by voluntarily invoking the jurisdiction of the federal courts. And that's from another Supreme Court case called College Savings Bank 2. So what these establish is that the state of Minnesota cannot claim in this disastrous assault on my First Amendment rights, cannot claim sovereign immunity under the 11th Amendment. That is according to an 8th Circuit precedent. Here the state of Minnesota, through the Department of Revenue, has appeared to file a proof of claim at the stage before the conversion to Chapter 7, waiving immunity under 11 U.S.C. 106B. And so the complaint specifically claims they have waived jurisdiction as follows. The state of Minnesota and Congress have waived and abrogated Minnesota's sovereign immunity under U.S.C. 106 A, B, and C by Minnesota's filing a claim for income taxes on plaintiff state unemployment benefits and federal emergency unemployment compensation benefits and wages earned and allowed under those programs from 2008 to 2011. Since all the subject matter of this proceeding arises from the same transaction as this lawsuit concerns, specifically the denial of funds owed by defendants to plaintiff in that same transaction and the same unemployment compensation program. So this was filed in Carlson versus the Minnesota Department of Employment and Economic Development and others in a case that was decided in the District Court of Minnesota in 2012. Now, another issue settled by this court conflicts with the panel's action, since appellees have contended that the Carlson's bankruptcy filing and the proceedings on taxation 1790 and my deprivation of EUC benefits and garnishment of my remaining $110 weekly to leave me with $35 weekly instead of $350 weekly from November 2010 to February 2011 are separate cases for immunity purposes. As discussed above, the bankruptcy case and the adversary proceedings are interrelated. Quote, disputes arising out of the adjudication of a single debt may be sufficiently intertwined so that a waiver in one respect applies to the others as well. See Price versus United States. That's from the 7th Circuit in 1994. The basis of both claims, tax liability and stay violation, revolve around the same aggregate core of facts, the debtor's unpaid taxes. Now that was that case, but these different issues revolve around the same aggregate core of facts, same claims and issues. Now the bankruptcy court's claim adjudication and discharge processes were both related to the scope and statuses in the Rose case of their student loan program's claim against their bankruptcy estate. The text of the bankruptcy code makes clear that these procedures are both part of a larger whole. That's quoting Rose. That's written by 8th Circuit Judge Diane Murphy. Now, like Rose, the state here in Carlson contends none had the authority to waive sovereign immunity in these separate adversary proceedings, but, quote, because the filing of the proofs of claim was adequate to waive immunity in related proceedings adjudicating the dischargeability of the debts claimed, we find this argument to be without merit. Now, a further difference in this case and the Rose case is that here damages are sought. Specific, express, and appropriate waiver of sovereign immunity by the Congress for all government units is effected in 11 U.S.C. 106A3, where it says the court may hear and determine any issue arising with respect to the application of such sections to government units. 3. The court may issue against the government unit an order, process, or judgment under such sections or the federal rules of bankruptcy procedure, including an order or judgment awarding a money recovery, but not including an award of punitive damages. That this provision intended to waive and abrogate sovereign immunity for the state of Minnesota in this case is expressed in the legislative history, where it says, in addition, the new 11 U.S.C. 106C provides, C, notwithstanding any assertion of sovereign immunity by a government unit, there shall be offset against the claim or interest of a government unit any claim against such governmental unit that is property of the estate, and an estate has been created. The legislative statement explains the congressional intent. Section 106C codifies in Ray William, 9th Circuit, 1975, and in Ray Dollard, 9th Circuit, 1975, permitting the bankruptcy court to determine the amount and dischargeability of tax liabilities owing by the debtor or the estate prior to and during a bankruptcy case, whether or not the governmental unit to which such taxes are owed files a proof of claim. Except as provided in sections 106A and B, subsection C is not limited to those issues, but permits the bankruptcy court to bind governmental units on other matters as well. For example, section 106C permits a trustee or debtor in possession to assert avoiding powers under Title 11 against a governmental unit. These other matters include both payment of EUC benefits owed and damages for violation of constitutional right. There's a case that was decided in 2006 called Central Virginia Community College versus Katz. Katz is clear that by filing a proof of claim, the state submits itself to determination of its claims and counterclaims against it in bankruptcy, which, as the Rose Court stated, is different than suits against the government outside of bankruptcy, since the bankruptcy clause waived sovereign immunity for the purpose of providing debtors a fresh start in accord with the bankruptcy code. As regarding due process and Younger Doctrine, looking at Pennzoil versus Texaco Incorporated. Now, what happened here is that constitutional damages are being sought against the state for intervening in this way during an election and completely depriving me of entitled income during that election without any prior notice or opportunity to be heard. And since that time, they're trying to avoid it being reviewed by any federal court. Now, as the cases to follow make clear, the 14th Amendment to the Constitution binds states to notice an opportunity to be heard prior to depriving a recipient of unemployment benefits of any kind. And the EUC benefits cannot be discontinued without this, since this benefit is clearly based on financial need, as in Goldberg versus Kelly Infra, unlike the disability benefits discussed in Matthews versus Eldridge Infra. And both of those are U.S. Supreme Court cases, and Goldberg is still good law. Now, and none of the appellees have ever asserted that they provided pre-deprivation due process, nor did the court below find that there was any. Instead, Magistrate Jeffrey Keyes depended solely on post-deprivation remedies, requiring first an appeal, then reconsideration, and finally a single shot at the Minnesota Court of Appeals. The failure to offer pre-deprivation process or any post-deprivation revelation of any possible grounds also violates the requirements of the Minnesota Supreme Court. In Juster Brothers versus Christgau, that's a Supreme Court case from 1943, it said that due process guarantees an applicant for unemployment benefits the opportunity to be present during the taking of testimony or evidence, to know the nature and contents of all evidence adduced in the matter, and present any relevant contentions and evidence the applicant may have. That's cited right in the complaint. Now, Minnesota also cites a U.S. Supreme Court case called Pennzoil. And in that case, they held that the Younger Doctrine, which is a kind of precedence that originated from a criminal case that involved pornography, now they're applying it to try to stop me from being able to challenge the cutoff and the financial attacks during a federal election. And they say that this Younger Doctrine abstention helps to avoid unwarranted determination of federal constitutional questions. Now, in that case, the plaintiff attempted to avoid bringing constitutional claims to the Texas state courts. But here I attempted from the beginning to challenge the constitutionality of the deprivation of benefits and due process, and was continuously rebuffed even at the Minnesota Court of Appeals. So this case must be distinguished from Pennzoil. The Pennzoil court continued saying, Younger abstention is mandated if the state's interests in the proceedings are so important that exercise of the federal judicial power would disregard the comity extended between the states and the national government. Appellees argue that they protect a vital or important state interest in enforcing the orders and judgments of the state court. Investigating a temporary restraining order giving me back pay from June 2011 to September 2010 would interfere with the execution of state judgments on grounds that challenge the very process by which those judgments were obtained. But in this case, there was no pending proceeding in any event since that ended December 27, 2011. Nor is respect of the proceedings on my first account, a unemployment account that was closed without me being paid anything, even due to the travesty of cover-up by the state apparatus, because they blatantly refused to follow Minnesota statutes or the order of Chief Judge Matthew Johnson that my appeal could not be dismissed as moot. Mindeed argued and got a judgment based on mootness. It would be, after that, it would be a travesty for the federal courts to allow this kind of conduct, let alone be mandated to ignore this disregard for the law and Constitution. And for this reason, I'm asking that the 8th Circuit Court of Appeals take this up en banc, that's sitting with the whole court, and make sure that they address the case in such a manner that they deal with it, not only in this case, but to protect the federal constitutional rights of anybody that runs for U.S. Congress in this district against Betty McCollum or against any candidate whose rights will be trampled and violated in the heat of an election just in a corrupt effort to attain federal office and all that power and money that they are trying to protect.